University welcome our chief guest, Advocate Mohit Khandelwal, Professor Dr. Komal Audicher, Dean School of Law, Assistant Professor and Coordinator of Moot Court Committee, Dr. Neetu Nuwal, Dr. Rohit Soni, and Dr. Rashmi Gupta, member of Moot Court Committee.
Before beginning of the event, we need two blessings of Ma Saraswati.
शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तु ते दीपज्योतिर्नमोऽस्तु ते शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः
We all are gathered here for the purpose of enhancing our legal advocacy skills through the Moot Court workshop by our eminent speaker. Since we all know for every student who are going to become an advocate in the near future, mooting is very important as an integral part of our education. Mooting helps us in overall development as an individual, enhancing our argumentative skills.
Before we dive in, let me briefly explain what moot court is all about. It is a basically replica of real court and legal proceedings and that take place. It stimulates court proceedings where students develop important skill of networking, researching, writing skills, building confidence, practical knowledge of the subject and learn the important teamwork. Since it is the most fundamental part of our career and future growth, we should have some crisp knowledge about mooting.
Now, we would like to call upon the stage Professor Dr. Komal Audicher, respected Dean, School of Law, to address the audience.
A very warm morning to the distinguished guest, Advocate Mohit Khandelwalji, dear colleagues and students. It's a pleasure to welcome all of you to this Moot Court workshop with the blessings of our chairman, R.P. Modi sir, and on behalf of School of Law, Modi University, I am honored to open this workshop that promises to be both enlightening and inspiring. At the outset, I would like to welcome and extend my heartfelt gratitude to the resource person of today's workshop, Advocate Mohit Khandelwalji, Rajasthan High Court. Thank you so much for graciously accepting our invitation, because all the way you have come from Jaipur to be a resource person in this workshop. And I think your passion, your dedication, your expertise in mooting will definitely make this workshop a valuable experience for all the participants. I remember earlier when we had called him, I was working in my previous workplace. So we met virtually online. So today I also feel blessed along with my students that we will be witness to his erudition skills and we feel blessed that his presence is somehow going to enhance our knowledge. Today we'll delve into the art of mooting, an essential skill for any aspiring lawyer. Moot Court provides a unique platform to develop critical legal skills, including research, drafting, oral advocacy, and it is not just an academic exercise, but it's a practical training ground for the real world legal skills. It enhances your ability to think on your feet, argue effectively, and present your case persuasively. Participation in any moot court competition for that matter, even if it is at local level, state level, national level, international level, it helps you to understand the intricacies of legal proceedings and courtroom etiquette. These skills are invaluable not only for your academic growth, but also your future, your career as a legal professional. During this workshop, we will cover various aspects of moot court. Of course, the common aspects of any moot court competition are the case preparation, when a hypothetical problem is given to you and you have to do extensive research work for the legal issues there. Oral advocacy, as I always tell all my students, I remember one of my students came from Hindi medium, and by the time he came to 4th year, just because he was regularly participating in mooting, he could take part in international moot court competitions. So the oral advocacy, it's not just your presentation, your communication skill, but it gives you the confidence also to speak on a public platform. Critical skills. It really makes you develop your analytical thinking and time management skills also. Crucial tools for any successful lawyer. You come to know about, because moot court is a mock court, you come to know about even the structure of a court and the research. The research tools which are latest available, which you can use for framing the legal issues and then citing the cases which are relevant to those legal issues. So it enhances your research work also, which is very important nowadays, because as you join even the academic profession, there also it's not just your degree only, but along with that they see your publications, your research work. So through mooting, your interest get awakened for research also. Memorandum, you have to prepare the persuasive memorials also in for your arguments, and which should be, as I just mentioned, well researched and logically structured. It's very important here, the engagement part, as Advocate Mohit also will be letting you know. Through moot court, you learn how to engage with judges, address their questions confidently, and adapt your strategy as needed. I was adjudging one of the events, relating to mooting only. So the speaker was very good, but she was not letting the judge, speak. She thought she had prepared so well, so it should be her chance only to speak. So you learn to have that kind of patience, that when judge is addressing to you, when judge is asking you some question, when judge is interacting with you, you have to stop there and listen to the judge at the first place. So you just not only learn all these things, but when it comes to your analytical thinking, you break down complex legal issues into manageable parts, analyze the facts, and apply the legal principles also effectively. Time management. We all know there is always a deadline to submit the memorials. There is always a deadline for your hard copy, soft copy of the memorials. So everything is time bound. So you learn the time management also in your preparation phase also and in your presentation also, because there is a time limit for your presenting the arguments. So you learn effectively to use time management also. So there are other common challenges. Moot courts can be, intense. There can be practice mindfulness and related, techniques to manage the stress and maintain focus also. Because the judge will always ask you difficult questions. That does not happen, of course, in real court. But during mooting, we try to judge the confidence of the speaker, the patience of the speaker. So that's why the questions asked are sometimes very difficult. So you come to know how you just have to tackle all these things. So dealing with difficult questions, you will be getting well, enhanced in this way also. I encourage each one of you today to engage in the session. You ask questions, take full advantage of our resource person and his expertise available. Remember, moot court is as much about learning and growing, but also competing also. So enhance and embrace every challenge as an opportunity to refine your skills today and deepen your understanding. Embrace your passion for the legal profession, and moot court, I'm letting you know, all the students here, it's an excellent way to explore different areas of law and discover yourself also. So today, as we embark on the journey together, I hope you find this workshop both educational and enjoyable, and let this be a time of learning, discovery, and inspiration as you build the skills that will serve you well throughout your legal career. Thank you for all the enthusiasm and commitment shown by the students. We have got little late in starting, but thank you so much for your patience. I wish you all a very, very productive and engaging workshop. My sincere gratitude to our chairman, R.P. Modi sir, for letting us organize such events, and to the management of Modi University for making the arrangements and allowing us to have this workshop. My sincere thanks to the organizers of this event, Dr. Neetu, Dr. Rashmi, and Dr. Rohit. Congratulations to you, and I hope you just have a very, very engaging workshop. Thank you so much.
Thank you, ma'am, for your insightful words and knowledge. With every case, a story unfolds. In pursuit of justice, the brave and bold, we learn,
We argue,
we rise.
we fall,
For us, the law is a journey.
a call for us all. Our eminent speaker for today is Advocate Mohit Khandelwal sir. He is a gold medalist in BA LLB from RJNLU Punjab. He has done his LLM in business law from University of Rajasthan. He is a managing proprietor of Mohit Khandelwal and associate, having team of over 10 practicing advocates and paralegals.
A renowned advocate with an impressive track in the field of law, his practicing as an advocate has an extensive experience in litigation matters relating to commercial law, criminal law, and service matter. He has argued more than 700 cases in the Rajasthan High Court, plenty of them being landmark judgments. He has published numerous research work in the field of taxation law.
Sir has participated in numerous international and national moot courts and also has been part of panel judging several part of moot court competitions. So his expertise and insight will guide us through this workshop, helping us to understand the intricacy of moot court and skill requisite to excel mooting skills.
We would like to call upon the stage Dean Ma'am for felicitating our chief guest. Thank you, sir and ma'am. I would request our chief guest to stay back on the stage to grace the event with his insight for work.
Good morning, everyone. Am I audible? First of all, thank you all for inviting me here. Special thanks to Komal ma'am, Neetu ma'am, Rohit sir, Rashmi ma'am for organizing this wonderful event. And I think they are doing a lot of things for your betterment. So let us make this count and let us at least share something which can help you and me both. So I think you all are from first year to fifth year? Yes. Fair enough. So have any of you participated in mooting till now? Any moot? How many of you? Okay, so we have considerable number of people who have participated in mooting. So anyone who can tell me what is mooting all about, out of your experience? It's an interactive section. I'm not dealing in any lecture here. So it's all about interaction between what I know and what you know, and that's what we have to do for at least next 2 years, 2 hours. So what is mooting all about? Anyone? Those who just raised their hands have done mooting. What is mooting all about? What have you experienced in mooting? Anything what you want to say? So I think you have not experienced anything in mooting till now. That's all about mooting. Feel confident. Mooting is all about knowing to speak and how to speak, when to speak and what to speak. So what have you learned? Please. Okay. Certainly. So you say that you apply your legal understanding to practical situation. Fair enough. I think that's one of the main object of mooting. Thank you. So before going in all these things, I'll first of all ask you, what do you think 5-year law is all about? And what was the need to start 5-year law and not to go ahead with 3-year law program which we were earlier having? The reason was, earlier what was the practice? The practice what you study for 3 years, then you join a chamber, learn the practical aspects of law, and then you become a counsel or a lawyer or an advocate, whatever you call it. But now things have gradually changed. People don't have much time to do this. Now you have integrated program in 5 years where you don't only learn the academic aspect or the legal aspect, you also learn the practical aspect in those 5 years. So when you move out, you are a trained counsel. You may join a chamber, but it is presumed that you are a counsel who can argue from the very first day. So if you want to prove that presumption correct, then you need to make sure that within the 5 years, when you are in law school, you enhance your skills to such an extent. So that is why if you ask me from my own particular experience, I divide my law school in 4 parts. Apart from my other activities, my roaming around and all these things which I may have done, I divide my law school in 4 parts. First is curriculum, academics which you are learning. You are being taught by your teachers, you are paying for examinations continuously, and once you clear the examination, you go to next semester. So that's the main curriculum part, that's the main academics. What else you can do in the law school? Anyone? What all can you do? Playing, sports, but I don't think that's part of main curriculum. That's something which should be done as a part of lifestyle, but that's not a part of curriculum, I say. What can be a part of curriculum apart from academics? Internships, that's great, one. Anything else? Legal writing, very good. Debating, fair enough. Anything else? Mooting, certainly we are discussing mooting, it should be. Okay, so I think I have got considerable answers which I was looking for. I divide my law school in 4 parts. First is academics, second is internship. Because even the BCI says that internship is an integral part of 5-year law school, for the reason that they want us to learn the practical aspects during these 5 years and not to wait for future period. So these 2 are mandatory. Then someone said content writing. I may say research article writing or publications. So that's also an integral part of law school. And then I say mooting. You also said debating. I say debating is something which is common to any college, school or university. In schools also you have been participating in debates. In school also you have been participating in the MUNs and other events, whether it is presidential form of debate or parliamentary form of debate, you have been doing it. But what is so particular about mooting, which is only being done in the law school? What is the difference between debate and mooting? Can anyone tell me? What is debating and mooting, and what distinguishes these 2? Certainly. Fair enough. I think that's a concise answer to what I was looking for. See, debating is more of informal event, where you are given a particular topic. You also have a particular topic in debating also. It's not that you speak on anything haywire. It has to be on a particular topic, you discuss on those topics. But it is more informal. When it comes to mooting, you think court in your mind. And whenever you think court in your mind, you think discipline. I think whenever you think of court, you think of discipline. Any person, even if you see a big history sheeter who has been shooting people across the country, when he goes to the court, he is disciplined. We are the councils, we have to follow that discipline. So discipline is the main key which comes with mooting, and it's an intellectual discussion on legal points. Though we have facts also, but mooting involves a discussion on law point with a person who is more intellectually smarter than you, that is the judge. You cannot say, ma'am rightly said, that whenever you are in court, you cannot presume that I am smarter than this judge. The time you do it, you are out of the court. Because in the court, it's not about knowing, it's about convincing. So courtroom etiquettes and mooting is all about convincing and not telling. Debating is about expressing your opinion. But in mooting, it's not about expressing your opinion. It's about bringing the judge along with your opinion. Are you getting the difference? That's the difference between mooting and debating. It's not about expression in mooting. It's about convincing the judge with facts, with law, and making him believe that what you are saying is correct. And then you want result in the end. Result means that you want an outcome which favors your client. Are you getting it? So the onus in mooting is much more bigger. You have to control your emotions, you have to control your personal bias, and you have to be very specific with what the judge wants to understand. And I am telling you, this is not about mooting, it's about legal profession. From doing moot court in my law school for 5 years and practicing for 6 years now, I can understand how mooting helped me in developing that skill to litigate and argue a case before the court. So I just told you 4 things, that what are the 4 prominent things in the law school. First, academics, second is research internship, third is research paper writing, and fourth is mooting. And you would see mooting is giving lot of importance in every law school, be it any law school across, not just in country but across the world. And that is why you see international moot court competition being organized across the country. So why is it so? Why do you think mooting is given so much of prominence and importance in 5-year law school? Because the kind of skill set mooting develops is something which cannot be done in any of the remaining 3. So what is mooting all about? As you said, you are given a case to argue, you have to prepare the case, present the case before the judge and argue and get the result in the end. But is it that easy? It is not. You see good debaters don't need to prepare. Supposedly, if you are a good debater in your law school, in your school or in your university, and you are told that tomorrow there is a debate in Delhi University, you go and argue, you go and debate, you will agree to it, okay, I'll do it. Certainly I can do it because I am a debater, I have been doing it all throughout. But can I say that tomorrow is a moot being organized in this Delhi University and you go and participate in the moot? Can I say yes? I think no. Why? Preparation. Preparation is the key. So what I am telling you, let's see how mooting is distinguished from the other parts of the law school and other parts of other co-curricular activities. In the mooting, you start with getting a fact sheet. The organizers give you a fact sheet which contains huge numerous facts on which are numerical also, arithmetic also, and otherwise also. So these fact sheets are given to you. You are being told that this is the incident which has taken place, whether it's a commercial event, whether it's a criminal law practice or a civil law event. You are given a particular event, and you are being told that now someone is aggrieved by something, and for that person you are supposed to approach the court and argue on his behalf. So once I get the fact sheet, what I am supposed to do? I have to read the facts and then start preparing. Preparing for what? Facts that I have known. Preparing for law which has to support my facts. Because every fact in the court must have the legal backing. The court cannot work without the law. You may have very good facts to present, but if it is not supported by law, you cannot win a case. Because we live in a country which is governed by rule of law. So when we say rule of law, we say that the law has to prevail over everything. So when the law has to prevail, you have to bring your case within the peripheries of law, and only then you can make a case before the court. Because the court strictly works as per law. If they don't, then you file an appeal and you move to the Supreme Court to get the law settled. So the task is that you have the fact sheet, you are supposed to apply, you are supposed to research day and night on the principles of law which are applicable. Once you get the statutory principles, you have to look for the precedents, judicial precedents, which you also call the case laws. You have to look for the case laws. Then you have to prepare a draft, which in the civil law we call pleading, and in the moot court language we call memorial. So you have to prepare the memorial for the court, you have to submit that memorial, then your physical rounds will take place for arguments, you have to argue the case, convince the judge, handle that questionnaire which the judge has for you, which consists of both factual aspects as well as legal aspects, and then eventually you will get the result. So it's an exercise which has numerous things involved. First is developing the legal understanding, because you read the law. Second is writing. You write what you read. Supposedly when you have read the fact sheet and you get the case laws with you, you have to prepare the memorial. So what is memorial? In memorial you present your arguments. So presenting arguments involves intellectual thought. Are you getting it? Writing facts is one thing, writing argument is another. So what is argument? If someone tell me in simple English language, what is argument? Yes, please. To defend yourself. Okay. I would say it's not about wrong or right, it's about convincing someone with my opinion. Are you getting the point? My opinion may be wrong or right. That's why we call it argument and not conclusion. I argue, judge has to decide. So what I am doing, I am presenting my opinion vociferously with my own, with all of my commitment. So that's what I do when we moot. So in academics, we learn the statutory principles, we learn the basics. Supposedly you are preparing for constitutional examination, so you will read all the articles of the constitution and you are supposed to write them in the examination. So that develops your skill of reading the law, understanding the law and presenting that after remembering the same. That's what we do in the examinations. Am I correct? Am I correct? That you suppose you're being taught in the classes that okay, these are the articles of the constitution. You go back, you prepare for examinations, you read all those articles, you learn mug up them, you read the judgments relevant to them and write them in examination. That is clear? So that develops your legal understanding and legal acumen. But what about applying those on facts? Because applying the law on facts is a real task. Knowing the law is one thing, trust me, I am telling you. When I was in my law school, I used to work really very hard, at least for 14 hours every day I used to work. I read every law with my heart. But when I came to practice, I could think that whatever I learned is not useful. Because whenever you get practical scenario, you have to revisit the law every time. Because then your perception changes. You have to understand the law in that perspective which suits to your facts. So that is what mooting teaches. Why I say article writing is good but not that good as compared to mooting, for the reason that in articles you present your opinion, be it by fact, be it by law. For example, I have written a lot of research articles. Supposedly there is a law principle which is being developed and I researched throughout on that law principle. I pulled all my judgments which I could get and I presented them in particular article, 5 pages, 10 pages, 15 pages. So that's also good because that develops your writing skill. Collecting the law and writing it is a task. For example, when you start reading the judgments on a particular point, you may find hundreds of judgments together. But now when you are supposed to present all that defined opinion of law in 5 pages, that's a task. And that's what we do in article writing. So article writing is also a very good thing to do which enables you in writing good law. And when your writing skill improves, you become a good counsel eventually. Because your draft goes to the court and the court comes reading your draft. If you are drafting well, half of the job is done. I am telling you half of the job is done. Leave aside the moot court. In real court also, when you file a SLP for the Honorable Supreme Court, the Honorable Supreme Court judges come reading the draft. And by the time they are in the court, they have partly framed their mind that what will I do in this case. Now these days Supreme Court is online, you can also see this if I am wrong. You will see that Honorable Judges of Supreme Court, before the lawyer starts arguing the case, they say, oh, Mr. So and so, we have read the case and this should be the opinion. And we are dismissing the SLP or we are admitting the SLP. So how they frame this opinion? Based on your own draft which you have given to them. So your draft carries so much of value. And trust me, these people don't have time. Always believe judges don't have time. They are always out of time. So whatever you give to them must be precise, concise and to the point. You cannot ask them to read 100 pages altogether. They will say I have to deal 100 cases, I cannot read 100 pages in each and every case, it amounts to 10,000 pages. That's not humanly possible for me to do it every day. So if I can concise my argument in minimal pages, communicating maximum fact and maximum law, that is legal skill which you have to develop. So you can develop this by 2 things. First is research writing, article writing, and second is mooting. But this add on to mooting. In the mooting, you just not frame your opinion, but you present your opinion as well by arguing the case. At the same time, you get the counter opinion from the other side, who will rebut you vociferously again. So if you want to really feel the real courtroom heat, then during the law school the best thing is mooting. Because the real courtroom heat which you are going to face when you are in court, judge is after your life, the other counsel is after your life, and you are also in trouble for the reason that you have to get relief for your client. So you are occupied with three stress at the same time. One is you have to answer to your client from whom you have taken the money, whose interest you are representing, and his life, property or interest is at stake. So you are not debating, okay, whatever it may be, I have presented my opinion. Your argument will have some repercussions on that particular client which you present. So you have much more onus to discharge. Again, you are doing it, the other counsel will counter you again with all these arguments. At the same time, judge will have his own opinion. Are you getting it? So dealing all of them together at the same time and representing the correct thing is what we call spontaneity. What is spontaneity? Being on your feet and able to decide what to do immediately. And that is a major aspect or major skill of a counsel and a law student. Why do you see lawyers are so intellectual? We always see lawyers are so intellectual, they can answer everything, they can handle any kind of query, any kind of question, any kind of bashing. Why so? Because they are trained in such manner to handle that stress, to handle that query immediately coming to them and answering them in the best way. Are you getting it? So that is a major skill which a lawyer must have. What are you doing these days to develop this skill? Anything which you do apart from arguing with each other? Anything else? That we do very, very often. We can spend a lot of time arguing with each other on any specific point. May it be irrelevant, but we can argue. But that skill, that's again a skill of counsel, to argue about something which is of no relevance. That's also required at times. But we have to be more particular and our arguments must be based on law. So whenever you argue with each other from today, make sure that it is backed by law. You cite judgments to each other. You cite principles of law to each other. Are you getting my point? I am telling you a skill to develop legal sense in you. So whenever you are quoting, talk about equality, talk about Article 14, talk about various principles of Article 14 which are there. So when you read the law, try inculcating that in your way of speaking, because there is a major difference in legal jargon and English jargon. I am telling you, ma'am correctly said that some people, even in my case I would say, when I joined my law school I was not very good at English. I was not. Let's accept the harsh reality. But eventually I knew that if you have to really perform well in law school as well as after going out of law school, you must be good orator. Because oratory skill is something which is most essential component of a counsel. Because at times you know everything but you can't communicate, then your knowledge goes in vain. So communication skill is the main key for any counsel, any lawyer, any judge, whatever profession you subsequently choose after completing your law. Communication skill is the must. And people believe that if lawyer is there with me, he can argue, he can represent. So the point is that in the law school you have to develop all these skills. So can anyone tell me what are you doing to develop these argumentative skills? Any practice which you specifically do at your own level? Reading? That's a great thing. Okay, then. But see, tell me one thing. We read a lot of things every day. I myself tell you, I read around 10-15 judgments every day. But are we able to remember all of them? Are we able to? No. So when will we remember them? When? Yes, that's one. I would simplify that. I will say when we start using them. Using them in our life. At times, let's take simple English language, you learn a lot of vocabulary. You read a lot of vocabulary every day. If you read an article or judgment of Supreme Court, you will find 10 new words in each and every judgment. But are you able to remember them? No. You will remember those which you start using in your own vocabulary. So, reading judgment may not help unless you start remembering them and using them. So, for that, I think mooting is the best exercise, because in mooting you prepare, you argue, and that goes throughout your life with you. I will give you a second important example of mooting, or the best thing about mooting. For a young counsel, supposedly eventually after 5 years you all are going to graduate from this law school and start practicing your profession in whatever way. Some of you may join the litigation, and some of you may think of joining the good chamber in High Court or Supreme Court. But then you will struggle to get an opportunity to argue before the High Court judges. You will be after the life of your senior to give you a brief to argue. Senior would say, I have charged from the client, I have to do it myself. But you will say that I have to learn, so allow me to argue. So you look each and every possible opportunity to argue before the Honorable High Court judges, District judges or Supreme Court judges, whatever it may be. And you will try to look for opportunity to present your case before them. And trust me, it's very difficult for a young counsel to get attention of the court at the tender age. Because judges also treat you a young counsel, unless you argue really well, they may not take you seriously. A senior advocate may get 10 minutes for doing nothing, but a junior advocate would not get even 10 seconds for doing nothing. You have to always be on your feet. If you are a young counsel in the court, your each and every second matters to the court and to you. If you waste even a single second of the court would throw you out. Okay, adjourned. Bring your senior. But in mooting, I have done a lot of mooting. We have gone throughout for a lot of moots across the country. In our final rounds, semi-final rounds, we argued before the Honorable High Court judges, sitting Supreme Court judges for an hour, and they were bound to listen to us. They were forced to, because they have chosen to be a judge there. They decided to come and judge the moot court by their own will. And now we have qualified for finals or semi-finals. Now they have to listen to us at least for half an hour, because that is a minimum time allotted to us by the moot committee. Are you getting it? So as a speaker in final round, I am supposed to get 25 minutes to argue. And for those 25 minutes, the panel of sitting Honorable High Court judges, Honorable Supreme Court judges, academicians, experts have to listen to me. Whatever I am talking, it may be good for nothing. They will say what he is talking about, but still they have to listen to me. What am I getting? Opportunity to argue before such a senior panel. Are you getting it? And they'll gill you, they'll teach you. That never happens in the court. They will teach you by dismissing your case in the court. But in moots you don't lose. You may lose the round, but you don't lose the career. In the courts you may lose the career by losing a case. Losing a single case may cause you a lot of things. So that is why I say you do all these things in law school itself. Why to put your career at risk by doing all these things after law school? And why not to do all these things in the law school itself? Let the sitting Supreme Court judges listen to your arguments, improve you, train you, because it's an academic exercise. Everyone wants to improve the skill of the student who is participating in the moot, from the preliminary round till the final round. But that is not the case in the real law school, in the real courtroom, because they have much more serious onus to discharge. They have to do justice there and not teach your skills. Are you getting? So that is why it's always good to participate in moots, argue before the experts who are coming from different fields, and learn from them. And that learning experience will teach you how to argue before the actual court, because there are two different things which you don't know as otherwise if you're not in law school. One is legal jargon, second is courtroom etiquettes. Legal jargon and courtroom etiquettes are not known to every person who is not from legal background. These two are specific to people who are from law background. I think you must also know that whatever words we use in the judgments, in the drafting, that's not normal English. I think all of you agree with this. So what are you doing to improve your legal jargon? What are you doing? Anyone? That's good. Anything else? Okay. Do we have some people who actually write them down also? That okay, I've read these few words and I'll now write this in my register or whatever you keep or diary, and then eventually start remembering them again. Do we have some hardworking people here? Yes? Don't tell it to me. That use it for answer writing in the examinations. That's not possible actually. I don't believe that. Absolutely, judiciary you may do it, but I don't believe for the college examinations you start using your vocabulary in law for writing the examinations. You at that time you target passing. Let's pass, let's write the right articles, write the right sections, and let's clear the examination. Then I'll think of legal jargon. I am very see, I am also coming from law school, and I'm telling you, I was much into law and reading all these things. But I also understand the practical aspects. That when I'm writing the examination, I am not thinking about developing my skills. My focus is to pass the examination with good marks, not just pass, but pass with good marks. So I don't see the opportunity to write the examination as an opportunity to develop my skills of writing. Not really. You may use your developed skills in writing examinations, but examinations cannot be used as a mechanism to develop this skill. So yes, anyone else who is noting them down, using them? Newspaper articles you try. Fair enough, that's good. But I will suggest you all to at least develop a habit of reading one judgment a day. Trust me, it's very easy if you do it, and it will help you a lot more time. It will pay you a lot more time eventually when you move out. Just develop one habit that I will read one Supreme Court judgment every day. Nothing more than that. This is beyond curriculum. Whatever you have been doing ordinarily, apart from that, you develop one judgment. That okay, I'll just read one judgment, write them down in my notebook. That is it. If you do it, then I'm telling you, you don't just develop your knowledge. You develop your vocabulary, you develop your understanding of law, because judgments are the only point where the facts, law and the precedents come together. Are you getting it? And these are the three things which you have to argue in the moot court. Why I am saying all these things to you? Because I want to connect that with the moot court. See what judgments do. What do the court do while writing the judgment? Anyone? Anyone? Yes, please.
Writing the judgment, we have the interpretation of different sections.
Okay.
So single sections, there are many interpretation we come through. Like there is a single section, and the interpretation of that single section, we have many interpretation, and through those interpretation, we come to know what this single section means, and through those interpretation only we come to know these. We make notes, and through those notes we are about whereabouts the legal maxims and what the judgments is all about.
Correct. But I don't, one of the perspective is correct, but I don't think the judgment is all about interpreting a section. It has lot more to carry. Anyone else who can add on this? Anyone else? There were a few who were saying that we read judgments. Where are those? Someone from here? Please. Okay. Yes. Correct. Correct. Which the court uses. Okay. So you say they apply the fact with law using the precedents. Fair enough. Anyone else? Yes, please. Okay, chaliye. I think you are correct to some extent, but I'll add on to one more aspect to that. See what happens. There are 3 criminal laws. What are those? Principal statutory laws, main principal laws. IPC, now we call it CRPC, now we call it evidence law, what we call it? साक्ष्य सहित. तो बहुत complicated, मैं simple बोलता हूँ, IPC, CRPC और evidence. These are 3 different statutes, but can they run in isolation? No value altogether. Why? Why? Anyone can tell me? Yes, please. Correct. So you say IPC is a statutory law, procedure is coming from CRPC, evidence is coming from Evidence Act. Anyone else who wants to add on?
So all these three are intricately interlinked.
Yes.
And one cannot exist without the another. IPC provides us with the punishment.
Succinctly.
But we cannot apply them on this without the procedure, proper procedures.
Certainly.
CRPC.
Certainly.
And now if we are proceeding to a court, we need to provide with the evidences and everything which is given in the evidence.
Correct. So now let's understand, when you're reading in your academics, when you read the CRPC, do you think of IPC? Very great, yeah. That's great. Do you think of evidence? Then you're very smart. मैं तो सोचा था कि यार IPC के सारे सेक्शन याद हो जाए वो बहुत है. फिर CRPC देखेंगे जब नेक्स्ट एग्जाम होगा तब. फिर एविडेंस देखेंगे जब उसका एग्जाम होगा. As of now IPC पढ़ लेते हैं. ये 500 बहुत है पढ़ने के लिए एक दिन में. Once I'm done with these, I'll come to CRPC next day, and then evidence. So my approach was this. But you're smarter. Young generation, there's a generation gap here. That happens at times. I think there's a generation gap which has taken place over the period of time. So the point is that if you are doing it, it's very good. If you are, while reading this CRPC, you can think of IPC and evidence law. That is great. And that is what the judgment do. That's what I was trying to tell you. Judgments do the same thing. When the courts are applied, supposedly there's a case before the court for murder, and the Honorable Supreme Court is called upon to decide whether the conviction was right or wrong. What will the court do? The court will first of all deal with the facts of the case. That okay, this incident took place. This is how this deceased was killed. That's something which they'll mention first. These are the brief facts they'll mention. Then they say okay, now the charge against him is 302. Read section 34, 139, whatever it may be, or 395. It's a case of dacoity as well. So this is the primary section statutory provisions for which he is charged for. Am I correct? Since you have well read the CRPC, IPC evidence, I am talking in that language. So he has been charged for those sections. But after charge, the real issue starts. Evidences. Now the council would challenge that, okay, see sir, the procedure of law which was bound to be followed has not been followed. He will say, okay, 313 was not complied with. What is 313 CRPC? Anyone? Well-read people, anyone? Fair enough. I think it's a very random question. I don't expect answer from you actually. Fair enough. You are meeting my expectations now. So what is 313? That okay, you are supposed to put all the inculpatory evidence which you have collected to the accused. Defense evidence किससे से पहले होता है वो साक्ष्य सफाई बोलते हैं उसको हम लोग. So it's a defense stage. So before the defense stage starts, you put all the incriminating circumstances to the accused and see what he has to say. So now at times the council may argue that sir 313 was not complied with. So I have not been duly tried. So that's one defense he'll take, and there will be multiple defenses coming on from his side in the CRPC. Similarly, they'll also argue that see evidence law says so, it has not been done with. So what they do, they bring to decide the guilt, they apply CRPC and evidence. Am I correct? I think it's very clear. So that is how the multiple laws goes together while dealing with a particular case, and that is now backed by previous judgments of the court. So this is how judgment is written: fact, law, case law, and that's what how a judgment is written, with a conclusion in the end, which deals with both the arguments and counter arguments, and then the conclusion based on law. Now when you are in mooting, what are you supposed to do? Same thing to the court. You are supposed to tell them facts which are of your side. I don't say which favors you, because the most important thing for a client and a counsel is to approach the doctrine of clean hands. You have to operate. You are supposed to always approach the court with clean hands. Be fair and write to the court, because those who are fair win the cases. I'll give a judgment of 2023. The Honorable Supreme Court dismissed the bail solely on this ground, that the counsel concealed one fact, that document, one of the documents which they filed before the Honorable Supreme Court was not filed before the Honorable High Court. Solely on this ground, the Honorable Supreme Court dismissed the bail application and also made an observation regarding the counsel. Are you getting it? So what am I trying to communicate you? That in a moot court competition or in a real court competition, whatever it may be, you are supposed to narrate the facts to the court. That's outright, because you presume judge know the law. If you start sorry, if you start telling the law to the judge, will he listen to you? Because who is the judge? Who knows the law? That's why he has been given that post. So he said, I don't need the law from you unless I ask for it. You first of all tell me what is the fact, I'll apply the law. Leave it on me. So it's also about managing things in the court, that without telling the judge that you don't know, you tell him everything. This is also a skill of argumentation, a skill of mooting, which you have to learn. Are you getting it? That without telling the judge that you don't know this law, I know this, I am telling you, you tell everything to him. Because if you tell the judge that you don't know this law and please read this, he will never read it, because it hurts his sentiments. Are you getting it? That is why a counsel has to be very pragmatic in approach. You have to see what the judge wants, how he wants to listen things. So in moot, what you are doing, you ultimately prepare the case, submit your research to the court, and then argue. While arguing, my approach was three. First is I will bring the facts to the court, the facts which are clear but specifically focused on my pleading, or which conveys my set of arguments. I cannot see I am fair, but I cannot be that fair that I say that सब इसने मर्डर किया है, सजा दे दो उसको, फिर मुझे वकील क्यों करेंगे? So you are supposed to be fair, but not that fair. Fair in the sense you are supposed to tell them, sir, this is the case which they have built, but this is not the true fact. I have the true fact to present. So you have to distract the case against you and make your case. That is all about argumentation on facts. And then you have to tell the law that see, whatever argued is not coming in vague. It is based on sound principles of law, and that is what I am telling you. Then the case law. At times you start putting case laws to the court. Is that the right approach? Someone say yes. Anyone? Case laws are binding precedents. See, I say the answer is not yes or no. The answer it depends. It depends on the judge. Supposedly I am arguing for the Honorable District Judge, and I have a judgment of Supreme Court saying the law which I want to tell him. I can say it with authority that, sir, Honorable Supreme Court has said it, and it binds you. With not arrogance, with compassion, I tell him. But my ultimate intent is to tell him that it binds you. You don't have the authority to change this. Are you getting it? Even if you do, even before the Honorable District Judge you show that arrogance, that okay, see, Supreme Court says so, and you are bound by it, he may distinguish it. वो simple एक line लिखते हैं कि I'll say that हिंदी because हिंदी डिस्ट्रिक्ट कोर्ट में चलती है कि प्रार्थी के अधिवक्ता द्वारा प्रस्तुत की गई न्यायिक दृष्टांत का न्यायपूर्वक अवलोकन किया गया, उनसे सहसंबद्ध उनसे गाइडेंस प्राप्त की गई, परंतु ये रूलिंग वर्तमान प्रकरण पर चस्पा नहीं होती. They'll simply say that law of this case does not apply on this fact. And I'll give you a multiple judge of Honorable Supreme Court from 1950 till today. The Honorable Supreme Court says that the judgments are not the statutory provisions. These are not to be applied like a statute. They would be applied on a particular set of facts. And these are not the grand norm. Are you getting it? So that is what the court would do. So even in the district court, if you are relying on Supreme Court judgment, you have to be compassionate, and you have to tell him that, sir, I am convincing you, but otherwise for your guidance, this is judgment of the Honorable Supreme Court. If you are arguing for the Honorable High Court might say that, see, I am not bound by it. I can make a distinguishment at my own. I can distinguish it. I am a constitutional court. And before the Honorable Supreme Court, nothing binds. If before the Honorable Supreme Court you say, sir, this is a binding principle, and if the judge thinks I don't agree with it, he'll refer it to the larger bench. So even a constitutional bench judgment before the Honorable Supreme Court may not bind them, because if you don't agree with it, they'll say found another constitutional bench to reconsider it. So that is why it is not good to start your case with a case law. Always start with the statutory principles, because law cannot be changed unless the Parliament amends it, and that's not a rare. That's a rare occasion. That's not a routine process. Are you getting my point? So whenever you are presenting a case before the moot court, in the moot court or the real court, you are supposed to tell the court the statutory law first, and then you say that, sir, this statutory law has been enunciated and developed further and explained by this honorable court in this judgment, which I am putting for your reference. This is how we build our argument. Am I correct? So that's how you do it in mooting also. So coming back to the point of mooting, I would say mooting is a comprehensive exercise for all these reasons. Firstly, you research. I think you must be using SCC Manupatra. How many of you? Okay. So what are you researching on? What are you researching it? Case laws regarding moots or research articles? Because I don't think there is anyone who will research Manupatra judgment for answer writing in examination. Anyone? I have not seen any of those such bright students, even in my law school. So is there anyone who research Manupatra and SCC for their academic examinations? That's great. Now you're ordinary. Great. So what are you using it for? Always, your university has spent a lot of money in Manupatra and SCC and all other legal software which they have given to you. What are you doing with all those? Research articles or moots. Fair enough, that's what they are meant for. So research articles and moots. So I think you are well equipped with the resources. So your college has provided you resources which are required for mooting. Okay, so college has done the job. Now the task lies with you to start mooting. So for that, let me tell you one thing. Okay, I think you know that moots are organized on different laws. It's not just our particular law. So can any of you name me few moots, few renowned moot court competitions? KK Luthra, yes, that's one. I think it's Hyderabad. The KK Luthra was organized by NLU Hyderabad earlier, I think, at our times. Maybe it has changed eventually. Okay, KK Luthra is one, yes, or? Nanavati is fine, okay. Ranka, local moot, we have to always say it's good moot. Okay, anything else? वो राका ही तो होता है मेरे हिसाब से जो FYLC राका होता है that's what they are organizing. They may have changed the sponsor, but to my knowledge this is Raka's trust was organizing it earlier. It's still them. Oh, fair enough. Okay, so anything else? Any international moot court competitions? Viz Vienna, Stefan, yeah, Jessup. Anything else? Viz, Jessup, Stetsons. These are the big international law moot court competitions, which are organized for students across the world, not just the country. So they are organized at the country level first. Those who qualify the country rounds go to international rounds and participate there. So these are basically based on international law principles or international law. Okay, so this is one aspect. Then you have national moots. Luthra, Nanavati, these are all are national moots. In those, teams from across the country participate. Are we clear with this? Okay. So, but in those also there is no fixed law. You find a lot of moots on constitutional law. You find a lot of moots on criminal law. Lot on even mock trial also organized. Surana organizes mock trial as well. Surana organizes mock trial. So in that they give you a flavor of trial. You are supposed to examine the witnesses in chief, in cross. So that's one of unit moot court competitions also. In that you really see a flavor of criminal trial taking place. So that's one. Then you have commercial law moots, constitutional law moots, civil right moots. Lot of moots take place on every law, environmental law for that matter. So I think you can decide your own area of interest initially and start participating in the area of law which makes you bit more comfortable in understanding. Are you getting it? There are people who have particular interest in particular area. Any of you who wants to practice in particular area of law? Not just in criminal practice as a lawyer, otherwise also as an academician or by doing a master's in that particular area of law. Anyone? Criminal law, civil law, because in our profession if you see, lawyers are not ready to be all-rounders. Generally people say, which area of law are you practicing? This is a common question which comes to me also. I say I practice in every area of law. I've been doing it, I like it, I like most of the laws. But it's a general question which comes to you, which area of law are you practicing in? So I am posing the same question to you, that supposedly you are supposed to decide a moot court competition. So the question is, which area of law will you go for? That's great. Some of you say criminal. Are all of you agreeing with this? We don't have constitutional law experts here? Jurists, eminent jurists? No one? Yeah, I have always seen people who are very keen in constitutional law and they can discuss constitutional law throughout their life and throughout the day at least. You don't have any of these? हमारे कॉलेज में बहुत थे यार जो कॉन्स्टिट्यूशन लॉ के एक्सपर्ट थे. No one? Fair enough. And commercial laws? No one? Who will join the corporate firms then? No placement? इसलिए firms आती नहीं है. Because you are not interested in corporate firms. There is no one who wants the placement? Few. Okay, just very few. So out of 100% of batch, I think only 2 or 3 are getting placed. And what rest of you, what will you do? Will you go for practice or judiciary? Judiciary. सबको जज बनना है, सर ने सही कहा. इसलिए कहना हमें तो सुनना है, सुनाना नहीं है. So that is why they are saying we'll do it by authority. Fair enough, but I am telling you, judges are always a task. ये कहना आसान है जज बनना, असली सुनना जज को ही पड़ता है. काउंसिल्स का तो क्या है, कुछ भी बोल जाएंगे कोर्ट में आके, जज को सुनना पड़ेगा. अगर पेशेंस किसी का टेस्ट करना है तो एक्चुअल में जज का करना होता है. But understand his profession, he is supposed to sit in the court at 10:30 until 4:30. And what is he supposed to do? Listen. He cannot say his opinion in the court. Because if you say your opinion in the court, you are biased. Supposedly, if one side is arguing, I say, यार आप सही बोल रहे हो. तो other side would say, साहब आप बचाए क्या बोलने के लिए? I'll give you a recent example of day before yesterday. Just before yesterday. There was a huge matter of injunction law. It was a civil suit injunction matter था. काफी I'm also presenting one of the clients there. And it's a good matter, huge matter. So very good civil law counsels of the district court of Jaipur were arguing that case. I was also presenting one side. So the plaintiff side argued behind our back. So because in district court in Jaipur, at least in Rajasthan, you don't have number being called like Delhi district courts. So you go at any time and argue. अगर आपको लगता है सामने को बुलाना तो फोन पे बुला लो, but there is no time fixed. 10:30 से 4:30 जब जज साहब फ्री हो, आप फ्री हो जाके बहस कर लो. So फिर क्या हुआ? They argued. And then I said, सब ये क्या बात हुई? वो मेरे पीछे से आर्ग्यू कर रहे, I don't know what they argued. और फिर हमने कहा हम आर्ग्यू नहीं करेंगे. And judge said कि मैं तो आज interim grant करूंगी. ये lady just said मैं तो आज interim grant करूंगी. समझ लो फर्क आप? Interim relief मतलब ad interim injunction she was talking about. तो उन्होंने सिर्फ एक शब्द कह दिया इंटरिम ग्रांट करूंगी एंड आवर आइज वर शॉक्ड. हम डिफेंडेंट थे, हम इंटरिम खारिज कराने आए थे. हमने ऐसा बहस करने मतलब क्या बचा, आपने कहा इंटरिम ग्रांट ही करूंगी, so there is no need to argue the case. आप तो बहस दो. The lady was judge was trying to say I will hear the interim. मैं वो बोल रही थी interim decide करूंगी, and mistakenly she said interim grant करूंगी, and trust me we were after her life. यार ये तो biasness हो गई, मतलब ही क्या बहस करने का, आप तो ग्रांट कर रहे हो, फिर हम डिसाइड क्यों कराएं, समझ रहे हो आप. तो that is a onus which judges to discharge. It's not that easy to be a judge. तो ये भी अगर आप mooting करोगे तो ये स्किल भी सीखोगे आप, how to listen patiently. ये mooting का एक पार्ट है, because when you are in moods, ma'am rightly said, you cannot be outspoken that you keep speaking and let the judge hear. He will take no interest in you. And you argue for an hour, he will keep reading his books. Okay, ठीक है. It happens at times. If you go in real court at times, judges sleep also. आप इतने boring हो, आपकी गलती है. You can't engage the judge, so that's your failure. Because he is also human. He is sitting from 10:30 to 4:30. If your arguments are so does not have any they are so lackluster and they cannot convince the judge, he'll sleep. So who is losing in the end? Not the judge. He'll get the salary. You are losing your case. You will losing your case. So convincing and keeping the judge along is a task, and that's what mooting teaches you. So in mooting, you are supposed to ensure that. Just let me know when the time is up. Just give me 5 minutes notice, I'll close it. Because I'm not having the clock with me, I'll just see. Because lawyers know how to, we can speak for an entire day. So yes, so what I was telling you, that in moot, even if you are a judge, you are supposed to listen patiently, frame a mind and decide. So all these skills can be developed while mooting. और ये सब छोड़ो, असली मूट से फायदा किसको होता है, किसको होता है, हैं? पार्टिसिपेंट्स को. आई डोंट अग्री. किसको होता है? कॉलेज को. क्या बात की आपने, कॉलेज आपके लिए सब कुछ करा, आपको कॉलेज को फायदा होता है, किसको होता है, हैं? मैं एक्चुअली आई पॉइंटेड हर आउट, बट शी इज करेक्ट. मैं कहूँगा यूनिवर्सिटी को. मूटिंग से असली फायदा यूनिवर्सिटी को होता है. बिकॉज व्हेन यू आर गोइंग फॉर मूट, यू आर नॉट रिप्रेजेंटिंग योरसेल्फ, यू आर रिप्रेजेंटिंग द यूनिवर्सिटी. आर यू गेटिंग द पॉइंट? एंड यू हैव मच मोर ओनर्स टू डिस्चार्ज. आर यू गेटिंग? जैसे होता है ना ओलंपिक्स में हम टीम इंडिया के लिए गए तो मेडल वो नहीं जीते, टीम इंडिया जीत रही है. वैसे ही when you are participating in moot court competition, they will never say X name, Y name, Z name. They'll say RG Annual. They'll say Modi University. So you don't represent yourself. You represent the college and university. So you perform good or bad, that represents your university. अगर आपने अच्छा परफॉर्म किया और आप जीत के आ गए, then I'm telling you, everyone would know university कि यार ये university है, बहुत अच्छे बच्चे कर रहे हैं क्या. And if you lose, you fail in prelim and you don't argue that saying, which university are you from? Are you getting it? So because it's not inside the college, it's outside the college. Whenever you're going outside the college, you represent the college and university. And you have to discharge that onus, because it's not just for you. Supposedly, a 4th year student goes for moot court competition and they perform nothing. Trust me, when the next year, the 3rd year person would go, he'll face that, okay, these are from that university which did nothing last time. So your good performance will benefit your juniors. Your bad performance will cost them. Are you getting it? But if you perform well in mooting, your university gets good name in country. तो यूनिवर्सिटी का नाम कैंपस बनाता है, लेकिन बाद में बच्चे बनाते हैं by winning these competitions. Why do we know NALSA are endless? Because those people did good work, went outside the country, won Jessup, won Stetson, won Viz. So outside the country, people knew that okay, this is endless. Are you getting it? So this is the most important advantage of mooting. that if you really want to create a brand from university, then you have to moot. Because those who go and perform and win, not just bring good things to their CV, but benefit the entire university, which will benefit all the students, not just you. अगर आप अच्छा परफॉर्म करते हो बाहर जाके, it will benefit all the students. So you are supposed to take this not as an event of going out and having picnic. It's an event where you have to discharge your onus of being a part of university. And trust me, when our university wins the moot, I'm telling you, when we went to NU Delhi for our insolvency law moot court competition, and that was really good moot court competition organized by Singapore-based firm, and it was first moot on insolvency law. Insolvency law was very new at that time in 16. Yes, 2016. So insolvency court came in 16. It was 16 itself. So NU Delhi was the first law school in the country to organize a moot court on insolvency law, and they had really good sponsors, all the partners, all the judges, and good senior advocates from Delhi and Supreme Court coming to judges their round and all these things. And our final was organized. We with good luck, we went into finals, and we eventually won the moot also. Everything went well and we won the moot. So the moot was held. Post moot, there was a conference of all the vice chancellors of all the NLUs being held in New Delhi. So all the vice chancellors of all the NLUs across the country came to New Delhi for the conference, which was supposed to be held immediately after our moot court comes to an end, and we won the moot. The vice chancellor of NU Delhi, Mr. Professor Ranveer Singh, very good professor, and our vice chancellor Dr. Paramjit Jaiswal, so they were good friends also. So when Dr. Jaiswal came to the campus in Delhi, I was there. I had an occasion to see all these things. Mr. Ranveer Singh hugged him that Paramjit, the university jeet gayi. And our vice chancellor was so happy. Amongst so many vice chancellors, the vice chancellor of NU Delhi says that your university performed outstandingly. So it was really an occasion for him, and that makes your NLU distinguished amongst other NLUs. And I'm telling you, he immediately called us and hugged all of us, our vice chancellor. Though he may not knowing me before that, but when we won it, he know that my students performed so well. He called us and hugged us. And then eventually when he went back to the university, he was so happy that he called us again and asked the moot court coordinator, the teacher coordinator, to make a publication in our portal that see this team has won the moot. It was not the first moot which we had won. It was not the first moot which our college has won. But he could realize the importance of mooting on that particular day, because he was overwhelmed with the way he was dealt with, but the way he was treated at the university. So he immediately asked that, okay, publish this moot winning on the portal. So that is how the winning of moot is not about a student, it is about the university. When you get this trophy, वो trophy घर पे नहीं लेके जाते कोई भी. हमने 5 trophies जीती, हमें एक भी नहीं मिली. वो सब वाइस चांसलर सर के ऑफिस में लगी हुई है. But that is university. वो university होती है. And you owe something towards university in which you are studying. Are you getting it? So you may be academically very good inside the college, but that is not sufficient, sir. You have to see the world outside. People are really working hard outside. At times we feel good. See, I am topping my class. I am really good at my academics. Fair enough. But you have not seen the world yet. The world is beyond your thinking, and you have to see the talent. You are supposed to see the talent outside. When you go out, you will realize what is the talent outside. I don't say you have less talent, but you have to compete with good talent. And when you compete with good talent, you nourish yourself. Are you getting it? So mooting gives you an opportunity to go out and compete with good people and realize what potential you have. If you lose, you have an option to learn. If you win, you again option have to improve. You can improve further and go for another moot and win another moot. Are you getting? So mooting is the most important thing for the university, for which you are supposed to do it not for yourself, but for your university and for all your juniors. Because if a senior wins a moot, he sets a trend. All juniors would approach him, sir, हमें भी सिखा दो, मैम हमें भी सिखा दो. I am telling you, this happens. जैसे होता है ना, आप you must have seen जो अच्छी यूनिवर्सिटीज़ होती है, जो जैसे DU हुआ, कोई भी हुआ, वहाँ पे देयर पीपल और हॉट, देयर स्टूडेंट्स और हॉट शॉट. हॉट शॉट जनरली कौन होते हैं? One, those who are very good sportsmen or sportswomen. Second, those who are really good in debating. Are you getting it? जो अच्छा बोलता है, एक तो वो हमेशा हॉट शॉट रहता है, और जो स्पोर्ट्स में अच्छा होता है, whether he or she whosoever is, वो हमेशा एक हॉट शॉट रहता है. वैसे लॉ स्कूल में हमेशा हॉट शॉट वो होता है जो मूटिंग में अच्छा होता है. Are you getting it? अगर आप मूटिंग में अच्छे हो, you are performing good for the college, you are winning moots, then not just inside the college but outside the college, you will get a lot of recognition. So if you want to get good recognition, you have to moot, and moot sincerely. All of that what I have said is comes to the rider. I always say that mooting is not the only thing to do in law school. I'll, with all sincerity, though I'm supposed to deliver the lecture on moot, but I'm supposed to bring to harsh reality also, because that's my duty as well. So mooting is not about participating. See, I never suggest mooting at the cost of academics. That is not what I ever suggest. In the law school, the first thing is academics. It is co-curricular, but it is not beyond curriculum. I sincerely deprecate the practice of those people who are failing in semesters but participating in moots. What is this? आपने सेमेस्टर तो पास हो नहीं रहे, मूट करना है. तो you have to maintain balance. आप अपने academics में अच्छा करें, and then as a co-curriculum you plan. Okay, in my 5 years I have to do 2, 3 moots, 4 moots, 5 moots. In one semester I'll do 1 moot. In 2 semesters I'll do 1 moot. This is smart planning, and accordingly you manage your time. And I have to give 1 or 2 months for this mooting. So accordingly I'll adjust. Okay, I'll prepare for moots at least for 5 hours a day. Are you getting it? So, and secondly, see, mooting का एक advantage और disadvantage दोनों है. Mooting values when you win in the end. Participation in mooting does not carry much CV value, because you have to think of future as well. So participating in mooting may not bring good CV. You may say that I have participated, but trust me, from being a student and employee, we hire a lot of people every day. So a lot of CVs come to me every day. So I see, okay, participation done, nahi, winner, okay, winner. Cause winning the moot matters in the end, not participation. But it is not that you are supposed to feel bad. हम fail हो गए तो हमने बहुत moot के बहुत हारे और बहुत जीते. So winning and losing is not a part for which you think before participating. But I am telling you, for the CV purpose, when you win the moot, it matters. So you cannot keep exhausting all your time in mooting. So you have to make balance. That in particular semester, I'll write 1 article, do 1 moot, and focus on curriculum, and plan accordingly. Okay. Now there is one more aspect of mooting which is very important. Some of you have participated in mooting. What is the team combination in mooting? Team combination. 2 speakers and 1 researcher. 2 speakers, okay, fair enough. Yeah, 2 speakers, 1 researcher. At times 2 speakers, 2 researchers. At times 3 speakers, 1 researcher. So different moots provide for different team combination, but generally it is 2 speakers, 1 researcher. So it's a 3-member team, which is ordinarily being followed in most of the moots. So see, at times you have seen people in our law schools also, we have seen people who are really good at doing work, but at their own level. ऐसे हैं कोई बहुत स्मार्ट है, बहुत इंटेलिजेंट है, पर काम खुद ही कर सकते, दूसरे के साथ नहीं कर सकते. है ऐसा कोई हाथ नहीं उठाएगा, उठाना भी नहीं चाहिए, मैं कह भी नहीं रहा. बट ऐसा होता है, वी रियलाइज इट आवरसेल्व्स कि आई एम रियली गुड एट वर्किंग, बट आई कैनॉट वर्क विद अ टीम. Are you getting it? Supposedly, if you are writing an article writing is something which I can sit in my room peacefully, I can do it myself. So I don't need to interact with anyone else. I'll open my Manupatra SCC, I'll research on my judgments, I will compile my research, I'll write it, send it to the publisher, he'll publish it, publication done. Most of the time I can go to my professor, ask them to proofread it, and that is how it is done. But mooting is not about doing this only. In moots, you have a team with you to perform. And mooting is a teamwork. No individual can win the moot. Are you getting it? So what mooting teaches you is teamwork. working with a team. Because if you want to eventually join any corporate house, as some of you showed interest in joining the corporate house, what is corporate firm? Corporate firm is basically 500, good corporate firm I'm talking about, tier 1 firms, 500, 600 lawyers working in a single roof. वकील तो एक ही भारी होता है, 600 वकील एक साथ काम कर रहे हैं in a single roof. It's very difficult to tackle them. All of them have their own opinion, खुद की सोच है, ये आर्टिकल पता है, वो पता है. So making them work together, specifically lawyers, it's a task, because lawyers have so much diverse opinion and it's very difficult to bring them on particular opinion, but it can be done by inculcating habit of teamwork, and the moots help in doing it. And that is why you see all the corporate firms, when they're looking at the CV, they see people who have done moots, who have won moots, because they see that if this person is doing moot and winning it consistently, then he knows how to work with a team. And that is how the law firm runs. Law firms cannot run with an individual, and they don't want people who can do it individually, because they know that from their partner till the associate, they have to all work together in a particular project. So mooting teaches you teamwork, because you have co-speaker to argue, you have your researcher. At times we see the researcher is treated like a assistant, but research is a key role to play. So that's how it takes place. In a mooting, when 3 people are working, you have to decide the issues to be argued. You have to divide, okay, you research on this topic, I'll research on this topic. You have to sum up your research together. You have to sit together several times. So don't make a team with people to whom you cannot see eye to eye. Because you will be required to sit together. You have to work for several days together in your rooms or in library, whatever it may be. So it's a good opportunity, and that's why you should utilize it. At times I have an habit of working individually. Then in such case you develop your habit, because right now you can change it, eventually may not. So in the mooting, when your work team is working together, you have to understand that what he can do, what I can do. For example, when I used to form a team in my law school, as I told you, I always thought that I am not that I was spontaneous, but I was not that flamboyant a speaker. Flamboyancy, flowery language, आप अच्छा एक jargon create कर दो. I used to think that in my initial years of law school that I am not that flamboyant a speaker. So, but I thought that I have some skill set which gives me advantage. That was spontaneity and understanding of law. That if you give me a legal proposition, whatsoever it may be, I can solve that within seconds. That's what I believed. I may be wrong. That's what I believed about my skills. So I always used to form a team with a person who is having good auditory skills. And then I always used to say that a first speaker of a moot, for example in a team, a first speaker of a team must be flamboyant. He sets the right narration, because what happens in the moot, when you go and argue, I am just going in process of how mooting argument takes place in mooting. First of all, the first speaker is supposed to recite the facts, issues before the court, what are the contentions to be raised. So within what 15 minutes you have, the first speaker is supposed to spend his 5 to 7 minutes in these initial parts, reciting the brief facts, reciting the brief issues, dividing the contentions and telling them what he will argue, what the other counsel will argue. It takes some time. So during this period, there is no legal argument which takes place. So if a speaker is flamboyant and he can really make the judge believe that I am well prepared, then it sets the right narration and right platform for the one to perform. Okay, because what happens at times is, if you are a very witty and smart speaker, the first speaker, if he is posed with any legal question, he will say, my lords, I am not dealing with it, my co-counsel will deal it. वो बंडल में पे शिफ्ट कर देगा कि my lords, your lordship's query is very clear and very categorical, but my lords, I am afraid that I am not dealing with this contention, my co-counsel is dealing it. वो जैसे co-counsel आया जज कहे बताओ पहले आपके counsel के गए आप बताओगे. So this is how it takes place in mooting. It's funny also. It happens in mooting that when you are arguing, judges poses you such a question which you don't know. You are blunt. You're blank. You don't know what to say. So either you say I plead ignorance, or you act smartly and shift the burden on the other counsel. So in such case, the second speaker must be the one who knows how to deal with the questions of law very clearly, and he must have good grasp of the facts, because by the time the first speaker completes, judges are well appraised with the facts. Now they will blast on the second speaker. Because how moots take place, judges are not the ones who are well read. They know the law. They are briefed for the moot proposition prior to the moot. For example, if moots are supposed to take place, there will be a briefing session which will take place. In the briefing sessions, all the judges are told about what is the fact of the case, and they hear the briefing. Based on the briefing, generally, if you talk about a judge like me, I may at times don't read the draft before coming to the moot court competition. I will say I am not supposed to read. The counsel is supposed to read. I am supposed to listen. They'll tell me what is the fact. Why should I put my effort? So I will just walk into the law school. I will go in their briefing session. They'll brief me of the facts. I'll go to the courtroom and start hearing the counsels. So in such case, actually I am not aware of the entire facts. So I will get to know about the facts. Eventually when the first speaker comes in, he tells me the facts, he tells me the contention, and I will spend my 5 to 7 minutes thinking, okay, this is also supposed to take place, okay, this is all there. And then by the time I am set with my mood, the first speaker goes off and second comes in. तो जो दिमाग में मेरी क्वेरी थी सब मैं उस पर डाल दूँगा, तुम बताओ. तो second speaker must have the onus of knowing what he is supposed to tell, but also what the other speaker was supposed to tell. But you can't, because second speaker can't say to judge, सब मुझे नहीं पता, उससे पूछते हैं. Because you are working as a team. You cannot shift the burden on each other and run away. The judge ultimately would judge you on the basis of team, that whether team A should win or team B should win. So it's a team effort. So team must have a combination of all these skills together. So जब भी मूट की टीम बनाओ, कभी दोस्त को देख के मत बनाना, हमेशा लड़ाई होगी. I've seen best of the friends fighting like anything in the end of the moot. At times they don't even go for the moot. Before that they fight up and call off the moot. So I don't say don't form teams with your friends. I'm saying that while forming the team in moot court, make sure that you come up with people who have that skill and mindset which matches with your caliber. Are you getting it? And then there is a third person called researcher. So very fairly, researcher is not the assistant of the speaker. He has been tasked with the aspect of preparing the memorial, but that's not his sole aspect. He will research you what ideally should be scenario, that supposedly when you get the moot proposition, you fact sheet, you read the facts, and after reading the fact, you decide the issues. What approach we used to follow? I would say that whenever you read the moot prop, every time you read the moot prop, you will find new things. So I had a policy with myself that supposedly moot is supposed to be held next month. Generally they give you 2 months time. In good commercial law, national law moots, they give you 2 to 3 months time to prepare. So once the moot prop is out, I and my teammates, we used to read the moot prop at least twice a day, at least for 2 months. अब आप हो गए 10 पेज थे, 10 बार क्यों पढ़ रहे हैं आपको? And trust me, वो भी कम थे. And when you go to argue, and then you read it again, आपको लगता है अरे ये argument मैं नहीं कर सकता हूँ. And at times you start arguing new things which you have not even mentioned in the moot proposition. Cause never think that I have completed my facts. I have the grasp for the fact. Every time you read, you develop new thought. And the more you read, the more thoughts you will develop. And it's all about intellectual thought. ये तो moot है. That noting the facts and using them for your betterment. So whenever you get a fact sheet of a moot competition, you read it not just once, twice. I suggest read it twice a day. Till the time you go and argue the case. सुबह पढ़ो, शाम को ठंडे दिमाग से पढ़ो. Keep reading it. And every time whatever thought comes to your mind, keep writing it. And then after, once you have done it with the basic reading, spend 4-5 days in reading the law. Library जाओ, मनुपात्र चलाओ, ऐसी चलाओ. For the first 5-4 days, you are supposed to read randomly about the moot propositions and the applicable laws. जो भी statutory principles applicable है वो पढ़े, and then you read the case laws. And after 4-5 days, all team members sit together and share your opinion, share your research. That see, after doing random research, I found this. After doing random research, I found this, and all 3 of you share research. And then after sharing your preliminary research, you frame the issues. That okay, after reading the entire proposition, now I think that these are the issues which can be made out in this case. Supposedly you make 6 issues, that we can explain the entire case to the court by arguing on 6 issues. So then divide 2 issues each. ऐसा मत करो, रिसर्चर आपको असिस्ट करेगा. You say that 2 issues 1 speaker, 2 issues second speaker, 2 issues the researcher. And that's how you divide the issues. And then you do issue-wise research. And then draft. Once you draft your set of issue, share it with the other speaker, other researcher, and you interchange or exchange. And the other person would do the same thing again. They'll also research. At times, one of the speaker may miss out something which the other person can cover. So it's a comprehensive exercise, smart exercise. So by doing so, you divide the work well. Everyone knows his set of obligations and duties, and everyone is well read. Not just about his part of arguments, but also what the other person is arguing. And that's how the team efforts comes in. Are you getting it? Am I making sense to you? Yes, sir. So what have you been doing till now? Those who have mooted, how do you pursue the moot? Out of your experience? Anyone? Yes. Chaliye, let's start it again. How many of you have mooted till now? Those who have mooted, have participated in any moot whatsoever? Raise your hand please, very clearly. So I see 5, 6 hands here. Some of you here. Okay, fair enough. So have you won any moot? Anyone? No? No issue. Now let's understand what, after participating in the moot, what did you realize that what was lacking? Anyone? Let's be very fair to ourselves. So after participating in the moot and not winning it, I think you must have made certain observations in the end, that this is not how I have to improve. So anyone who want to share the experience of what they have gained? See, losing means you have gained your experience. So it's not losing, it's a preparation for the next win. Okay, so what experience have you gained? Anyone? What was lacking? Yes? Fair enough. That's very good. तो मैं मान नहीं सकता ये बात. मूटिंग में अच्छी बात है, मूटिंग में दोनों साइड से आर्ग्यू करना होता है आपको. अगर आपको दोनों साइड गलत लग रही है फिर तो अपना फॉल्ट है. एक साइड तो सही होगी. आई गॉट योर पॉइंट. ऐसा होता है. क्या होता है? एवरी मूट प्रॉप हैज अ वीकर साइड. आई गेट अ पॉइंट. एवरी मूट प्रॉप हैज अ वीकर साइड. But that is why in the moots you are allowed to argue from both the sides. In preliminary rounds. In quarters, in semis, you may not be asked to argue for one side, but in preliminary rounds, you are supposed to argue for both the sides. You prepare memorials for both the sides. Am I correct? It is for this reason only. That you don't feel biased. You don't feel cheated कि यार मेरे को गलत साइड दी, मैं क्या करूँगा? ऐसा होता है क्वार्टर सेमीज में आपको वो साइड मिल जाती है जो साइड वीक है, बट उससे फर्क नहीं पड़ता because judges know it. See, I have judged lot many moot court competitions after my law school. I have went across lot many NLUs and other platforms and judged moot court competitions. We don't judge a student or participant on the basis of what arguments they make, how they read the fact, or what facts they have presented. We understand by doing it that okay, this prop is one-sided. That's what judges can understand quite well. After hearing both sides, okay, the fact is इनके खिलाफ है क्या करेंगे? But we judge the students on the basis of their confidence, on the basis of their understanding of law, on the basis of their etiquettes and court mannerism. Because mooting में फैसला ही देना, फैसला इस बात का देना है कौन सी साइड ने अच्छा परफॉर्म किया, इस बात का नहीं केस कौन जीतेगा, अपील डिसमिस जो अलाउ, ये नहीं करना हमें करना है विच साइड परफॉर्म बेटर. तो वो इशू वहाँ आता है जब कोर्ट में डिसाइड करना होता है कि तो वीकर साइड में तो हारना ही कि मैं क्या करूँ. जैसे आपको केस में लड़ रहा हूँ, आई नो दैट साइड इज वीक, तो आई लूज. यस yes. Okay. Sir, one-sided prop, we call it. Yes. Yes. that is what, that is where you have to break the ice. Understand, that is a skill which you have to develop. A lawyer cannot be biased. I am telling you, if you yourself believe that my client is weak, you cannot argue in the court. Arguing the court means arguing with full conviction and commitment. So when you argue for the court, you tell the court, okay, I am wrong at this point, I accept, but I have a better point to argue. And that is where the law comes to save you. When your facts are weak, you have to support yourself with law. If the facts are strong, there is no need for law. I am telling you, when there is a good case on facts, we don't need to tell the court what the law is. Law comes in picture, case law comes in picture when the court says, I am dismissing your case. Dismissed. Then we have to tell the court, sir, you cannot do it because I have this law to help me out in one way or the other. Are you getting it? So the time you realize that this side is weak, it means you have to research more for that side. And eventually you will realize that, okay, I have researched so much that this side appears to be weak, the other side appears to be weak. See, I'll tell you, the moot prop cannot be one-sided. For the reason that when a person is drafting the moot prop, they are supposed to organize a moot court competition. And competition means fair chance to both the parties. If you say in real life it happens, it can happen. If someone has committed the murder, there is a videograph of murder being committed, I can say that, okay, it's a weak case. And there is a video of that he has killed someone apparently. Then also we have to defend that case. But in a moot prop, it cannot be one-sided. If it appears to be one-sided, then it is your fault in reading the moot prop. Because the organizer would not make a moot one-sided. They have to allow both the parties to contest. Okay, so never think that moot, it happens that certain facts favor one party, certain may not favor the other party. That is fine. 60-40 हो सकता है, पर 90-10 कभी नहीं हो सकता. और जहाँ 60-40 हो गया, then 10% has to be covered by the law. And then at that time you have to argue on law. And tell the court, sir, I have understanding of law and this law favors my case. And if you are able to do it, then I am telling you, you will win the round. Judge would say, okay, she is not having good facts with her to argue, but she is very good on law. We can't beat her on law, and they will give you extra marks for this. As a judge, I have seen both the sides very well. As a participant, we always knew that, okay, this is the weaker side. Then we have to basically we have to back our case basically on law, and we have to pull in a lot of case laws, a lot of statutory provisions, and we have to convince the court that, okay, this applies in our case. But as a judge, we realize that, okay, this is a weak side. Then we never grill the arguing counsel on the facts. We always grill them on law. That if they can stand the question of law, if they can answer the question of law, they'll get the marks. Are you getting it? So when you are preparing for moot court, you never think that one side is weak. So I think you argued from both the sides. In a moot court, you argue from both the sides. So if one side was weak, other side was strong. Have you won that round? Anyone? I'm having a general question. Okay, I would accept that point that, okay, your side was weak in one round. But have you won the other round in which you were strong? Don't answer me, answer yourself. I'm not expecting any answer from you in this point. But I'm telling you, let's introspect. Introspect to the extent that in the moot court, it is not about appeal allowed or dismissed. It's all about your performance. So you have to develop a good performance to argue. You have to develop a skill set which just think, yaar, ye bachcha itna acha kar raha hai. He's yet to become a counsel. In his early years of law school, he's doing so well. He's having so much understanding of law. So judges appreciate a good understanding of law and good oratory skill. And that is what mooting helps you to develop. Are you getting it? So once you are preparing for the moot, never think that this side will lose or this side would win. Your only task is to present a better case before the court. That's what a lawyer is supposed to do. A lawyer cannot decide which side would win. At times, the cases which appears to be really good on one side ultimately get dismissed. It happens in court every day. That you go and think it's a very good case, I will surely get it, no issue. And you get dismissed on the first day. At times you think it's a very weak case, judge would dismiss me and throw me out with cost on the very first day. And that petition gets allowed in the end. So in the court, apart from the moot, also I am telling you, even when you go to practical realities later on, never think that I will not win, because the time you think it, you lose your confidence, and if you lose your confidence, then it is the end of the game. Are you getting it? So okay, let's understand all of any other thing. What difficulties you have faced apart from this? That moot prop is one-sided. That's one. Anything else? Yes. This is genuine difficulty. This is genuine difficulty, and it's a difficulty with everyone, because you have so much to say, but you don't know how to say it, and that is what we call structuring of the argument, and that's a task. That's something which you have to develop over the years. Are you getting it? That is why you do mooting, to develop that skill of argumentation, structuring of the argument. Supposedly you have so many things to say, you have so many judgments, you have 100 judgments in favor of your. For example, when you draft a memorial, when we used to draft a memorial, we used to cite 200 judgments in the memorial. But can we argue 200 judgments before the court? No, not at all. Our compendium cannot exceed beyond 10 judgments. He will not listen even to 10 judgments for that matter. So out of 200, I am supposed to check and think that what judgment should I actually tell to the court when I am arguing in those 5-10 minutes. This is a decision which we have to make, that which are the most important fact which I need to tell to the court. So most important facts are something which you have to pull out first, and then most important statutory principles. Then you have to pull 1 or 2 judgments which actually substantiates your case, having similar facts, having similar issues, and decided in your favor. Are you getting it? So structuring is your argument takes time. That's something which you have to work on. I'll give you basically an example of how you can do it. So once you are done with the memorial submission, you get at least 10-15 days to prepare for the oral arguments. That's a normal time which we get. So after completing your memorial, once you are done with the filing of the memorial, your team sit together, prepare your arguments. First round. In the first round, you will perform within your team. You start arguing in front of your team members who know everything about for example, speaker 1 speaks, speaker 2 and the researcher becomes the judge. And they will cross question the speaker 1. Okay, that you speak your facts, you speak your case, and we'll cross question you, we'll grill you basically. So that's the first round, because your speaker 2 and the researcher knows all your weak and strong points, and they can pull you on all those points, that okay, this is a difficulty which you will face, we'll ask you right now, and you can prepare a suitable reply for the same at that very time and practice it again. Are you getting it? So this is round 1. Subsequently, supposedly if you are in first year or second year, you have some seniors in the college, you go to them, you ask them, sir, please spend out some time and take our oral rounds. That's what we used to do in our college, and that's what the Moot committee has been doing officially also. In our college there was a system that before going for any national moot or international moot, you have to prepare and you have to give 3 official oral rounds to the team or to the panel of judges fixed by the Moot committee. Are you getting it? So basically when we were in 4th and 5th year, so Moot committee used to say, sir, please, if these second year students, third year students are going for Moot, you please take their oral rounds. So the seniors used to take out their time after the college, and they used to judge those students who are going for participation. Then out of their experience they'll ask questions, out of their experience they'll put them queries, they'll help them out how to enhance their arguments, how to argue in a better manner. That's how they'll do. If third stage, if you can think of, if you are really hard working, then you can even approach your professors. That, sir, we have prepared this, we are preparing for this moot, and we are done with the submission. We are supposed to argue the case before the court on such particular date. So we are facing this difficulty in answering these queries. I think they can also help you out. So when you start working, there are many things which you can do actually. You may also know some of your friends in other law schools. You can take their help. You can ask them to take your oral rounds on through video conferencing. So if you really make an effort, you can do everything. And after doing all these things, so before we normally thought at that time that before going for actual moot court argument before the judge in the moot court competition, we must at least give 10 to 20 oral arguments before the other benches, which may comprise my own team, which may comprise my seniors, my teachers, other people. So once you argue the same case at least 10 to 20 times before the other benches and answer all their queries, satisfy all their queries, then at times when you go to the actual moot, you see whatever they are asking is already covered. So it becomes a cakewalk for you. But that all requires hard work, which you have to pour in. No one else can do it. If you put an effort, everyone will join you, but you have to take the initiative. Are you getting it? So if you prepare it in such a manner, then when you go to the actual arguments, you will realize that whatever is being asked to me is known to me. And by that time, after giving 20 oral rounds, your argument should be well structured. That when you go before the court, you are pinpoint specific as to what you have to say. Are you getting it? And trust me, this is what you have to develop. If you go to Honorable High Court for arguments, they'll give you a minute to argue, not more than that. In a minute, if you can make out a case, fair enough, otherwise they'll throw your file. Are you getting it? So you have just minutes to count on. That is why I am saying spontaneity is all about this profession. And that is what you have to develop. Spontaneity will not come automatically. It will come only when you put efforts in understanding law, reading law, developing your understanding of law, and argumentative skills. When you do all these things, only then you can get the spontaneity to argue for the courts, in real court. Are we clear? So this is how you prepare the oral arguments. Anyone else? Yes? Are done with the time? Let me know. I think that's almost covered. We have almost covered all these things which we were supposed to tell. Yeah. Yes, please. Yes, please. Correct. Correct. Okay. See, I'll tell you one thing. Moot courts memorial have two things. First thing is formatting and editing. How you format and edit your moot court memorial. It should be well edited, well formatted. Second is your argumentative structure. How well you have structured your argument. These two things we check. Third is, when I check a lot of memorials also. So when I get the proposition, I ask the moot committee to give me the landmark judgments which favor this side and that side. Not about the other judgments, there may be many, but generally what happens is that moot propositions are based on some running propositions, some running issues, or some settled issues in some judgments, and mixed bunch of them. So there are judgments which favor one parties, and these are the landmark judgments which party must rely on. So we used to check the research. In the memorial there are several marks for several things. For research, I'll just go to the list of cases which they have prepared, and I'll see that okay, these are the 5 judgments which are landmark judgment. I'll check whether these 5 have been mentioned in the memorial or not. If they have mentioned, then you qualify the first round. Research is well. You get the marks for research. Second, I will say how you have structured them. Second is structuring. How you structure your argument to use those judgments in your favor. Third is formatting and editing. If it does not look well, no one would read it. So your memorial must look good. Sorry. I'll give you a lot of memorials which we have prepared. We used to prepare memorials for, at times in Delhi we prepared memorial for 200 pages. It was so innovative that because I was telling you about insolvency law, it was a new law at that time. So no one knew how it would run. So we brought an innovative approach, and we dealt with all the forms which were there in the insolvency code. And by using those law forms prescribed under law, we prepared our memorial. And trust me, it was a 200-page huge voluminous bunch, and throughout that memorial survived, and we won the best memorial also. So memorial must show innovation. If you are doing, see, research is done, after that your basically it must have good grammar, good language. I don't say that you put fancy language into it. Law does not require fancy language. Law requires good communication. It can be done with simple English also. So the law never, apart from good legal jargon, good legal terms which you must use surely because you are a student of law, it does not require good English jargon otherwise. If it is well communicated, that will work. After that, you must say that okay, I have researched well, edited well, and then you will get good marks. I'll take a break. Actually, I was having a bad throat yesterday also. Okay. That's not really good. I'll take a break. Okay. Any other query? Anyone? Okay. So just to summarize as to what we have done, my objects are three. Firstly, to encourage you for mooting. Secondly, to tell you how to moot. Third is that I cannot tell you how specifically you have to moot, because that is based on fact to fact, case to case, and moot to moot. So if you are really good learner, if you supposedly you face difficulty of how to prepare the memorials, when you participate in a moot, you get the moot allotted from the moot committee. Then you look for the moot memorials of that moot prepared by the previous teams or previous colleges also. If you can really contact people well, you can even pull out memorials from other colleges also. Take help of them and then prepare the draft. So while drafting memorial, you can, I think moot committee can also collect, we can also provide if required for, you can collect sample memorials from different colleges, you can develop your own, and that will help you out in understanding how to develop the memorial. You will get the format, but research you have to do. No one can help you with research. That's something which you have to put your effort in. So once you put your effort in researching and pull all these things together, then you have a format in which you can put all these things. And formatting carries marks. So I always say good memorial must have good formatting and good editing, because that always carries 10 to 20 marks in the moot court competition. Out of 100, I give 20 marks for editing, because you must know how to present well. Okay, and then you can take help from your people around, prepare good argument and argue there. If you lose, then you sit in other rounds and understand that those team which won, what arguments have they presented, so as to that one they won and we lost. So once you lose the moot, it's not a running time that okay, let's go back home. you should stick there and attend other rounds, semi-final rounds, final rounds, and you should learn that I also had the same facts, I also had the same research. What difference had they made? When you start realizing that, the second moot which you go for, you will win it. So losing one or two moot should not discourage you. Rather, it should encourage you to participate further. And in the third moot, you should target winning. Are you getting it? So that's what I can tell you. It's a long process. Eventually, when you do it, you learn it. Thank you. Thank you. Thank you. I'll take leave. So once again, thank you all for calling me here and for patiently listening. And I wish best of luck to all of you, so as to participate. You allow and I encourage you all to participate in the moots and win it for your college, for your dean, and for your professors. That's what we can give to them. Are you getting it? Because whatever knowledge we get in the college, we must show it outside. When we show it outside, it tells people that okay, we are having good professors in the college who are teaching us well. Are you getting it? So moot court is all about the university in the end, not about the individual. Thank you. because you have not seen the real world. Before seeing the real world, you have reached the conclusion. Let's बोलना है, अच्छी बात है, मैं let's बोलो. I also come from family of judges, but I don't want to be judge. Then अच्छी चीज़ है, आप telling me what are the professions which you can pursue? One, become a judge, become a counsel, join a corporate, go for masters, become an academician. These are the mainstream professions which a lawyer can pursue after 5 years. But there are not many more to come. There are people who leave all these things and become photographers. I've seen many. So I'm not doing all these. I'm like, mainstream चार professions. So when I'm in my first year, I'll tell you about myself. When I went to the college, I had a keen interest in corporate law. I today also have a corporate law interest. I am a qualified company secretary as well. I did my commercial law CS along with my law school itself. And I pursued all the commercial law moves throughout my law school. I won all of them. I wrote all my articles in commercial law. And I wanted to join a law firm. Amarchand, Sam, Cam, JC, whichever law firm I get. I got to the antitrust Moot, which is a Moot organized by NLU also, in collaboration with Shatul Amarchand, Sam. And Sam has a policy that those who win the Moot will get internships in the Sam directly. So I kept applying for Sam for internships in my second year. They never responded to me. All my emails were sent in junk. They never responded to me. Eventually, we won the Moot. We got the internship automatically de facto by winning the Moot. I went to Sam. I initially joined the competition law team because we won the competition law Moot. I asked them I have my interest in general corporate law, not in competition law. Okay. So I went to the competition law and I asked them please shift to me to general corp. They shifted me to general corp. Now in general corp I work there. I always love company law, commercial law like anything. That is my passion. But I realized that corporate firm is not for me. For initial 3 years, my passion was to join the corporate firm. And that is what I pursued throughout. And I wanted to get placed by any cost in good law firm. And when I interned there, at first time I realized I don't want to work here. But I was shocked that I was preparing for it for 3 years. Now I say I don't want to join it. I said let me rethink again. So I got a callback option from the SAM. I went for the callback for the second internship. That again reaffirmed me that I don't want to come here again. I worked there again for 1 month, but I realized that this is not what I want to do. I love corporate law, but not the corporate firm. So this was my individual perspective. I don't say corporate firm is bad. It is very good. People are doing outstandingly well. And people from good NLUs are joining there at a good package and doing really well. So I say it's good, but not for me. I have not liked that work culture there. I thought I can practice as a counsel and I can do well. So when I could realize it, only when I did it. Are you getting it? If on the first day I think that okay, I will do this, I have no second option. It is not the case. You can decide the option when you try for it. Some of you may be suitable for judiciary, some of you may not be. Some of you argue really well. They can't listen sitting for the entire day and listen to someone. They say that I can be outspoken, I can argue the case. Why should I become a judge? I will become a counsel, then become a high court judge. I don't say this is wrong, but you must choose at what stage I should enter into it. I should become a lower judiciary judge, I should join higher judiciary, or I should directly join the High Court or Supreme Court. These days, on Supreme Court is directly elevating lawyers to Supreme Court. Are you getting it? So, you should not decide as to what you will do. Please sit. I'll just
Please join coaching after passing out from here.
Yes, I was coming on that only. Why do you want to join the coaching? See, if you want to prepare for civils, I would say that joining coaching makes sense. If you are preparing for civils, then I can understand that what you are being taught here may not be of much relevance for you in the civil examinations, for IAS examinations, for state civils. But what is judiciary all about? Writing the law which you are reading here. IPC, CRPC, Constitution, whatever law you talk about, it is a part of your curriculum in the law school. So when something is a part of curriculum, you can read that while being a part of curriculum. Why do you want to join that coaching for extra effort? Rather, I advise you, suppose you know that IPC is something which is which IPC, CRPC, evidence, Constitution. These are the 4 major subjects for the judicial examinations. Am I right? Okay. So do you have IPC in your curriculum? You have it. But what mindset do we carry? that in class we'll just think of passing. Then we'll join the coaching in 5th year or 4th year, and then we'll hear the professor and read IPC seriously. Strange approach. You are reading the same IPC in the class, you do it at that time itself. So will the IPC change after 2 years? No. The same IPC remains. अरे अब नहीं होगी दोबारा, अब एक बार हो गई. It's an event which takes place in decades और centuries ऐसे. 1860 का तब हुआ है ना, अब थोड़ा हो जाएगा. तो अगले 100 साल तो नहीं होगा. ठीक है. और हो भी गए तो it's just a change of number of section number. The content is remained the same throughout, majorly. Okay. So you have bad luck, I can't help it. But otherwise I'm telling you, normal scenario. So why do you wish to target this point that okay, in 3rd and 4th year I'll join the coaching and start preparing for my judiciary examinations, when you have the same course in your curriculum? So I would rather advise that supposedly when you study IPC, we have a very good senior of ours who was in 5th year when I was in 1st year, and he was topper of his batch. He was from Jaipur only, so I went to him to ask him, sir, कुछ guidance दो. मैं 1st year में हुआ, 5th year में हुआ, topper भी हूँ. So right now he's placed in very good PSU, doing really good to himself. So he told me that Mohit, if you really want to do good thing, out of his 5 years experience, he told me that there are 4 major subjects which will get IPC, CRPC, contracts, constitution, transfer property act, so on and so forth. So whenever you read this judgment, read these subjects in your curriculum, in your semester. So whenever the semester starts, you make it a point that I will prepare notes for each and every section, for at least 2 sections in a day. He said that you read just 2 sections in a day and prepare notes for them in your own handwriting. समझ लीजिए आपने IPC start किया. You start from section 1. Section 1 and 2 first day. You have a semester for at least 4 to 5 months. You just prepare for 2 sections each day. Section पढ़ा, relevant judgment पढ़ा, उसको book में लिख, अपने notes में लिख लिया. Done? ऐसे आपने पूरे semester किया. फिर आप क्लास भी जा रहे हो, क्लास में टीचर भी पढ़ा रहे हैं. They are also giving your notes. They also give their own case laws, relevant sections, relevant case laws, and you note them down. Are you getting it? So ultimately, if in that particular semester you focus on that particular subject and you prepare your own notes by reading the commentary which you want to read subsequently and by attending the class in attentive manner, then in that semester you are thorough with that subject. You have 2 advantages. You will top the semester. You will become a judge without paying for coaching classes. But that's some huge mentality which we carry that okay, in class I'll not study, subsequently I'll join the coaching and then I'll study. What is this? So I don't say that they are also very good professors, I'm not saying so. But I am saying that when you can learn something in your curriculum, why don't you do it at that time? If subsequently you feel that I need further coaching, you do it. But not participating in curriculum and going for it does not make sense. Now I am coming back to the topic that for the first 3 years, you should not think of what I will do. You should think that I will do everything. And you don't think of future, you think of learning the law. By doing 4 things which I told you: curriculum, internship, mooting, and research paper. First 3 years, you should extensively plan for all those 4 things in all 6 semesters. After completing the 6th semester, you should think of future. That now I have done all these things, I have a good CV to make, and now I should think what I would actually pursue. In the 4th year, you finalize it after seeing all these things in internship. In the internship, you intern with a corporate firm, you intern with a lawyer, you intern with a judge, and you intern with research organizations also. And then you see which side attracts you after actually realizing what they're doing. And then in the 4th year, you take a sensitive call or a smart call that I will do this. And then accordingly, you spend next 2 years in doing for what you have thought of. In first year, you say that I will go for judiciary or I will go for litigation. I have seen people who say I have to litigate. So for the 5 years I have to chill. I'll subsequently go and join a council and prepare there. They're fools, because you have wasted the 5 years of law. Are you getting it? And I am a student of economics. I had done my BA in economics, so I always understand the term of opportunity cost. Opportunity cost is something which every economics student would understand. What is opportunity cost? Next best alternative. second best option. Are you getting it? So when I move out of law school, I may go for judiciary, but what is the opportunity cost which I have? What is the opportunity cost? Who will determine that? Who will do it? Your CV. Your CV will determine your opportunity cost. That what have you earned in those 3 years or those 5 years. So your CV must carry opportunity cost that okay, I will go for judiciary, I will go for litigation, but if not, then I have a person who can earn a lakh a month because of my CV. So that's what you have to work for 5 years and do anything in the end. Are you getting it? So don't close your eyes initially first 3 years. You have to decide, take a conscious call only in 4th year. That's what I can tell you. So now your difficulty is solved. You have to not think of coaching. You can focus on what you are doing, and a simple human person can at least work for 10 to 12 hours a day. So if you are working for 10 to 12 hours a day, if you are attending classes, then also you have sufficient time to work with. In that you can plan moots, you can plan research papers, you can plan academics, and that's what you have to do. Those who plan well succeed. Those who fail to plan do not succeed. Thank you.
Thank you, sir.
It was indeed an enlightening session. Your wise word will undoubtedly benefit our student.
Now, we would like to call Dr. Neetu Nuwal, Assistant Professor and Coordinator of Moot Court Committee, School of Law, for vote of thanks.
Namaskar to all present here. Namaskar. Namaskar, sir. Indeed, it was very excellent session and good interaction with the students. As we know, mooting is part of our curriculum and enhance the knowledge about the proceeding of court. Very first, on behalf of the School of Law, Modi University, I want to express my sincere gratitude and admiration for the outstanding lecture delivered by our eminent speaker, Advocate Mohit Khandelwalji. Sir, special thanks for giving our students your precious time and grace the occasion. My sincere gratitude to Chairman, respected R.P. Modi, sir. With his blessing and grace, we are able to conduct this workshop. Sir, your leadership, direction and dedication to our institution, academic and extracurricular curricular goals have been invaluable. I express sincere thanks to our esteemed Dean, Dr. Komal ma'am, who has been a source of support and inspiration. I would extend my gratitude to administration authorities on behalf of School of Law. Thank you for making this event to great success. This workshop was not possible without the help of Moot Court Committee members, Dr. Rohit Soni, Dr. Rashmi Gupta. We are very thankful to also the Moot Court Student Committee members as a good back supporter. It is our privilege to extend our heartfelt thanks to faculty members of the School of Law. I would also like to acknowledge the effort of auditorium management staff have been working tirelessly to ensure that every aspect of our event ran seamlessly. I want to express our heartfelt appreciation to our dedicated admission and technical team who have worked behind the scene to ensure the event success. Last but not least, I big thanks to our law students to make this event memorable. Your presence and engagement have added to the vibrancy of this workshop. Thank you everyone too.
Thank you, ma'am, for your words.
Now we would request all of you to stand for the national anthem.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे